This is Nick Thompson from Louisville, Kentucky. I've had 30 years of experience doing bankruptcies, and one of the common questions is what's the automatic stay and the discharge? You really should know the difference between the two. When you file the bankruptcy, the very second you file that bankruptcy, there's something called an automatic stay that goes into effect. This covers you, it covers your creditors, it covers the attorney himself. The automatic stay is a federal court order that says that no one can touch the property or attempt to collect from you the second you file the bankruptcy. This automatic stay is a temporary court order. It doesn't last forever. It acts during the period of time between the time you file the case to the time that the case ends, which is the time the discharge takes over. The discharge is the permanent court order that protects you from creditor harassment and collection to the day you die. Okay, permanent. But what is the difference between that automatic stay and the discharge, and why is it important? Okay, the idea of the automatic stay is that creditors should not interfere with the trustee and the court itself. The trustee and the court itself is trying to administer your assets, trying to protect you during the period of time that you're in their courthouse. Okay. So if creditors come along and they violate that automatic stay, they didn't just harm you, they harmed the judge and the trustee as well. So the automatic stay is extremely strong. Okay. Here is where the court itself, the judge, is going to get extremely upset and will harshly punish a creditor for attempting to collect a debt or taking possession of collateral during the period of time that the court is trying to manage this and the trustee is trying to manage this. You have not only affected the debtor, you've also damaged the court and caused the court time, effort, cost, and therefore the court's going to come down very hard on a creditor. It's very rare for a creditor to ever do anything during the course of the bankruptcy. That's why if you're letting your car go back, if you happen to be letting the house go back, during the period of time that you're in bankruptcy, typically they're not going to come out and repossess that car. They're not going to try to foreclose it during that 4 or 5 months that you're in that Chapter 7 bankruptcy. They'll wait until the bankruptcy is over and then come pick out the car, normally. Okay. Now, the discharge is the permanent court order that says that no one can collect from you for that debt unless the debt is non-dischargeable. There are certain debts that are non-dischargeable, such as child support, alimony, student loans. Secured debts are also what we think of as non-dischargeable as lawyers. It may be that they can't collect from you, but they can certainly go after the property that they have as security. Okay, so these are the items that protect you while you are in bankruptcy court and after bankruptcy court. It is contempt of court for the creditor to come after you have discharged the debt from them or while you're in bankruptcy. The creditor, if it wants to proceed in a foreclosure or wants to proceed and take possession of that car, then that creditor can file a motion to terminate the stay while you're in that Chapter 7 or that Chapter 13 if you're not making the payments in the Chapter 13 plan on time. Or if the creditor wants to take that car and it clearly has a lien against that car and the right to take that car eventually, they may pay the additional attorney fees and they may pay the additional court costs to proceed and take that car by filing that motion to terminate the stay. You have to plan these things out. And you want to make sure that you are able to stay in that house or stay in that car while you're going through this transitionary period. You're filing a budget, and it's not the budget that you had before, it's an entirely new budget. And you need to adapt to that. These protections protect you during that period of time. You can be temporarily protected by just simply hiring an attorney. You can come into an attorney's office, start to file a bankruptcy, sign a contract, retain them, pay a very minor fee, $50 to get it started. And that will stop a third-party collector, such as a collection agency or a law firm, from coming after you for a short period of time, because that debt collector can only then connect with the attorney and contact the attorney about the debt. He can't call you up. He can't write to you, okay? Once that attorney knows that you're represented by another attorney, the attorney can only talk to that attorney. He can file a lawsuit against you, perhaps, but that lawsuit will take months before he gets a judgment, okay? These things are things that you have to plan out. You have to plan out with an experienced attorney. You don't want someone who doesn't know this area of the law. It gets extremely complicated. We're happy to spend time with you, an hour or two, to plan what you need to do under these circumstances. It's free. And we give you the answers so that you can take back your life and get started on a fresh start in a new life with a new budget. This is Nick Thompson. I'm here in Louisville, Kentucky, and I'm happy to help you. Thank you.